Hi, my name's Dean Brown. I've been asked by Pret to spend a little bit of time with you today just to run through the new changes to the Privacy Act and how that might apply to your business as in your practice as real estate agents. One of the reasons I've been asked to do this today is I'm not only a lawyer, I'm also a licensed real estate agent, and so having experience in both, it was deemed to be someone who might be able to help you out with some relevant information. So what I'm going to talk about today is firstly, it shouldn't be construed as legal advice. It's just general information only, but hopefully at the end of this little session you'll be not only better informed about the changes to the Act, but really about how you can look at the changes and make some decisions and apply it to your practice as a real estate agent. So firstly, the Act is the Privacy Act 1988. The amendments, or the Privacy Amendments Enhancing Privacy Protection Act of 2012 came into effect in the 12th of March this year. Now, one of the more significant changes that is brought along is 13 privacy principles, and they are the first go-to, I suppose, as to how things you need to comply with, and then you can use that as a guide to what you need to change in your agency practice to comply with those amendments. Now, before I move on, I should mention that there are some penalties involved in the Act, substantial penalties in fact. The Act provides for civil penalties of 2,000 penalty units. Penalty unit is $170, so you can do your own sums. There are also provisions for criminal penalties. However, I would think that the sort of information we're talking about today wouldn't be getting into areas where you may be breaching criminal penalties, but there is a provision in the Act for that to happen. So I don't want to make this too boring and read you out word for word parts of the Act, but unfortunately the initial part I'm just going to need to do that, so please bear with me for a moment. So firstly, and this will help you understand where the Act is coming from, and again hopefully help you apply this to your business. So firstly, what are the objects of the Act? Well, that can be found in Section 2, capital A. So the objects of the Act are to promote the protection of privacy of individuals, to recognise that the protection of the privacy of individuals is balanced with interests of entities in carrying out their functions, to provide the basis of nationally consistent regulation of privacy in the handling of personal information, to promote responsible and transparent handling of the information, to facilitate an efficient credit reporting system, while ensuring that the privacy of individuals is respected, to facilitate the free flow of information, to provide a means for individuals to complain about alleged interference with their privacy, and to implement Australia's international obligation in relation to privacy. So I probably should mention now too that one of the reasons this is important, our society is changing, access to personal information is becoming easier, we constantly having people asking for our information. Information is getting sent across international borders. So it's really important that we know that if an entity has our information, that it's looked after properly. The other thing that you should be aware of, and this is why the importance of these statutes or legislation, is that there's no tort of privacy. Our system of common law system is we have torts of trespass. If someone punches you or trespasses on your property, or you lose money through them breaching a contract with you, we've got protection under statute, but we've also got protection in our legal system of the common law principles and judgments that have accrued over time. But there's no tort of privacy. This concept of privacy is something that's only really developed in recent decades. So most of our protection really is to be found in the legislation, not so much in common law. So it is important. We are seeing now that with paparazzi and people like that are impinging on the personal space of celebrities, taking photographs while they're think they're in private and publishing that information. As you know, you may have read in the papers, there's been some cases lately of these people being penalised, but it's only recently that these issues have become an issue. So our really protection is in the statute rather than in common law. Now, who does this Privacy Act apply to? Do you and your business have to comply with these requirements of the Act? So it applies to Australian federal government agencies. It applies to Australian Capital Territory and Norfolk Island government agencies. It applies to private sector businesses and private schools with annual turnover greater than 3 million, private sector health service providers and government-owned corporations. You might say, great, I'm a real estate agent, I've got a small business, I don't turn over 3 million a year, I don't have to comply. But wait, there's more. All right, so you don't turn over more than $3 million, does it apply to you? So what we have to do is look at the Act. So we look at Part 2 in the Act in interpretation. So it has some definitions. Now, an APP entity means an agency or an organisation. Now, Section 6, capital C, discusses what are organisations within the Act. So an organisation means an individual, a body corporate, or a partnership, any other unincorporated association or a trust. That is not a small business operator, registered political party or agency. So you can see that an organisation is quite broad. It can be an individual or body corporate. So, you know, they're alive to the idea that people might try and create separate entities or artificial entities to try and, you know, get around their obligations. So you can see it's fairly broad. It's pretty difficult to escape that. Also, it provides for legal people can be treated as different organisations in different capacities. So you might be a director of a company, you might of a trust, which is a trustee. They're aware that these your obligations, regardless of your relationship in here, can still come under the Act. So we then to see whether your small business, your real estate agency turning over less than $3 million is going to be under the umbrella of the Act. So if you look at Section 6, capital D, it discusses what are small businesses and small business operators. So it says that entities that are not small businesses, and it goes through a few different things, but subsection C and D. Subsection C says entities that are not small businesses are organisations that discloses personal information about another individual to anyone else for a benefit, service or advantage, or D, provides a benefit, service or advantage to collect personal information about another individual from anyone else. So I would think we'd all agree that as real estate agencies, we're doing that. We're collecting personal information on behalf of somebody else, and we're doing that to assist us making a profit. So regardless of your turnover, under the definitions of this Act, you are not a small business. Now, it also discusses different types of information, and it treats information differently depending on whether it's personal information or sensitive information. So personal information means information or opinion about an identified individual who is reasonably identifiable, whether the information or opinion is true or not, and whether the information or opinion is recorded in a material form or not. So it's information that can identify an individual, doesn't have to be true, can be an opinion. It also doesn't have to be in a material form or not. So what does that mean? That means that information you get doesn't have to be reduced to writing. So it might be personal information that through the course of your business you gather that is only something you're aware of. It is still personal information. So that personal information is treated the same as whether it's in writing. The Act differentiates between personal and sensitive information. So sensitive information means information or opinion about an individual's race or ethnic origin, their political opinions, membership of political associations, religious beliefs or affiliations, philosophical beliefs, membership of professional or trade associations, membership of a trade union, their sexual orientation or practice, criminal record, health information, genetic information, biometric information, and so on. So for the most part, I would think as a real estate agent, the sensitive information would have little impact on your operations. So what I'm going to talk about today is going to be just about personal information. We won't talk about sensitive information. I mean, there'd be very little instances, I would think, where you may be required to gather sensitive information. So, the information, personal information. Now, the Act also treats it differently about whether the information is solicited or unsolicited. So solicited information is, or you solicit if, and this is found in the Schedule 1 of the Act, entity solicits personal information if the entity requests another entity to provide the personal information or to provide a kind of information in which that personal information is included. So when would we solicit information in a real estate agency practice? You would solicit information if you're doing an open house and you're asking people for their name and their phone number. You would be soliciting information when you're receiving a tenancy application. Someone's filling out a form to put in an application for a tenancy. That's soliciting. When would you, so we're looking at OFIs, buyer inquiry, offers to purchase. If someone is putting an offer on a property, they're providing you and you're soliciting that information to facilitate that offer. Do you have a Twitter account? Do you have a Facebook account? You know, how is the information, what information do you gather that way? Is it personal information? Do you solicit it or unsolicited? These are all things you need to think about in the nature of your business. Now, we're going to talk about the privacy principles, and there's 13 privacy principles, and we're just going to briefly look on each one and see how that applies to your real estate agency practice. I'll also get you to think about what we've discussed and about how you apply a legal solution or a solution to a legal problem. So we're going to talk about IRAC. You identify the issue, what is the rule, apply that rule and come to a conclusion. So hopefully what we'll go through today will allow you to do that, where in your practice you're presented with a problem, you're able to think, okay, is this personal information? Is it sensitive information? Has it been solicited? Has it been unsolicited? And depending on those questions, the outcomes of those questions, you can then decide on what you need to do in a particular situation. What I'd like to do now, before we go too much further, is just take a moment to go through a simple formula that you may find beneficial in applying this legislation to your business. The thing about legislation or statute is that when the people who write or draft the laws don't really know your business. And sometimes the difficulty you face as a business owner is applying the legislation that's been drafted by a bureaucrat in Canberra to the operations of your business. So how do you do that? Now, we've discussed how this legislation applies to you, but let's give you a bit of a tool to help you then apply different circumstances to your business. So a basic formula or method of looking at legal type problems is to use this simple formula. So we look at IRAC. I-R-A-C. So we look at the issue. What is the issue? For example, we've discussed the difference between personal information and sensitive information. We've discussed the difference between solicited and unsolicited information. You're presented with a problem and one of your staff says, well, we've got information this way. How do we deal with it? We don't really know. This is a bit different. So firstly, you'd look at what's the issue. You've got information. Firstly, is it personal information? Is it sensitive information? Has it been solicited? Is it unsolicited? So that's the issue. The issue is the personal information, how you've got it. You then look at the rule. What's the rule? So we now know, or you know now will know how to look for the information. So it's personal information, it's been solicited, what does the Act say? What is the rule for how you treat that information? Are you allowed to give it out? Are you allowed to give it to a third person? Unsolicited information or solicited information. So let's think about it. Open house. We've got solicited information. It's personal information. Can I provide that information to a mortgage broker? Can I get paid a fee for providing that information to a mortgage broker? So what is the rule? What does the rule say? You then apply the rule, and then you come up with a conclusion as to how you deal with it. So you identify what the issue is. You look to the rule. What does the Act say? We know where to go for the rule now. We go to the Act. We look at the definitions. We look at the privacy principles. We then apply that to our situation, and then we come up with a conclusion. So I hope that will help as we go through these 13 privacy principles, and we just briefly look at some of the different scenarios. Give some thought to some of the scenarios that you deal with on a regular basis in your practice. And when you finish looking at this video, give some thought when you're out there over the next few weeks and looking at how to apply this in your day-to-day business. Use this as a guide. What's the issue? What's the rule? Then apply it, and then come up with a conclusion. So privacy principle 1, open and transparent management of personal information. Reasonable steps, you must take reasonable steps to implement practices and procedures to comply and to deal with inquiries and complaints. You must have an up-to-date privacy policy. You must take reasonable steps to make privacy policy available. And the Act makes mention of a good way to do that is on your website. So if you have a website, you should be looking at getting your privacy principle up there pretty much straight away. What other applications are there for a real estate agency practice? Well, when else would you be thinking possible you need to make your privacy policy available? A website obviously is a start. Do you need to have it as an open home? Maybe you don't. Maybe you need to have one copy there. Maybe you need to ensure that on your promotional material you have your website and point out that that's where your privacy policy can be found. Now, the Act Principle 1 also discusses, as an APP entity, what your privacy policy must contain. And that can be found in Privacy Principle 1, which is found as the Schedule 1 at the Act. So if you go to, nowadays it's fairly easy to find these things, you go to Google, type in privacy policy and follow the links, and you'd probably get onto the legislation. But it's a common law legislation. Make sure you're looking at the current Act and go to Schedule 1, which is found at the back. And it will list the privacy principles, and in Privacy Principle 1 it'll run through the things that must be shown on your privacy policy, and I'll discuss them just quickly. It must show the kinds of personal information that the entity collects and holds, the purpose for which the entity collects and holds, uses and discloses the information, how an individual may access the information, how someone may complain about any breach, whether the entity is likely to disclose that information, in particular to overseas recipients, and if it is likely to be disclosed to an overseas recipient, the country where it may be located, and if practical, specify that in the policy. So let's look at Privacy Policy 2, anonymity and pseudonymity. So an individual must have the option of not identifying themselves or using a pseudonym. It does not apply if it's impractical. I would think for most instances in real estate agency practice it would be fairly impractical. People need to know who they're dealing with. Even if you're receiving an offer on behalf for someone, they could hardly remain anonymous because you're working for the seller, so you'd have a duty to disclose that to the seller anyway. So I don't know whether that would have too many applications to real estate agency practice. Privacy Principle 3, collection of solicited personal information. So it must be reasonably necessary for your function or activities. You can only use lawful and fair means. and collect information only from the individual unless it is unreasonable or impractical to do so. Privacy principle 4, dealing with unsolicited personal information. Now, if you receive personal information that you did not solicit, you must, within a reasonable period after receiving the information, make a determination or decide whether or not you could have collected that information under Privacy Principle 3. So you've received the information in an unsolicited fashion. You then have to look at, well, could I have received that information by soliciting, by asking for it? Now, if you determine reasonably that you could have done that reasonably, you know, you can choose to use it. If you decide that no, you couldn't reasonably have got that information through solicited means, you then have to make a decision about whether you destroy it, or you should, as soon as practical, destroy it, or at least de-identify the information. You are allowed to use the personal information you have. Bit of doublespeak. You can use the information you have to make that determination. But if it's unsolicited information and you determine that you wouldn't have been able to get that information from soliciting it in a normal course of your activity, you really should be destroying the information, or at least de-identifying the information. Notification of collection of personal information at or before the time, or if that is not practical, as soon as practical after you collect personal information about an individual, you must take such steps, if any, as are reasonable in the circumstances, to notify the individual of such matters, that you have the information, and ensure that the individual aware of that the information includes identity and contact details, if it was collected from another individual, the purpose for which it's collected, and anyone else that information is disclosed to, and how they can access the information. Now, you're collecting information, how do you use that in practice? So you've solicited information at a open house. What obligations do you have then? Well, at the very minimum, you would need to be able to show to the people who you've collected the information from, how they can access your privacy policy. Now, you may decide that that's adequately addressed by, on your promotional material, having a website pointing out that's where your privacy policy is. You may decide that you also want to have your privacy policy available at an open house, for example, to give them a hard copy. You know, that's a decision for you and how practical that is. But in some way or other, you have to be able to provide these people with an option of, and tell them how their information is going to be dealt with. Privacy Policy 6, or Principle 6, use or disclose of the personal information. So if you hold personal information about an individual that was collected for a particular purpose, you must not use or disclose the information for another purpose, a secondary purpose. The individual, unless the individual has consented to the use or disclosure of the information. Again, let's look at how can we apply this to your business. It's reasonable for a potential buyer or a tenant making an application for a rental property, for them to, they provide the personal information to you, and it would be reasonable for them to expect that you are going to use that information for processing the tenancy application, or if they were a buyer coming through, to make contact with them, let them know or get feedback about the property that they've then had a look at, or even to advise them of other properties. That would be reasonable. What you couldn't do without their express consent is to provide that information to another entity, say a mortgage broker, finance broker, an insurance broker, someone else. So they've seen you, they're giving you that personal information to come through a house that you might be marketing, or for a tenancy application. What wouldn't be reasonable for them to do, and would be a breach of these requirements, is for you then to use that information and pass it on to somebody else for them to use. So if it's used for a second, because that would be a secondary purpose. So think about the purposes you're getting the information. So often the problem isn't going to be getting the information, providing you use it for the purpose that it was intended and don't disclose of it to anyone else. Where you may get into trouble though is where you're then using that for another purpose, in particular if they don't grant consent. Direct marketing. Now this touches on again what we do as real estate agents. So if you hold personal information about an individual, you must not use or disclose the information for the purpose of direct marketing unless the organisation collected the information from the individual and the individual would reasonably expect the organisation to use or disclose the information, and the organisation provides a simple means by which an individual may easily request not to receive more direct marketing communication, and the individual has not made such a request to the organisation. So how do we apply that? You get information. It would be reasonable from buyers, for example, it would be reasonable for you then to be able to make contact with them and let them know of other properties that come on the market, or put on your email list. However, you need to give them the option to not receive any more of that information. And once they've given such a notice they don't want to receive any information, they must be given the opportunity. You must not continue to send them information. Privacy Principle 8. Cross-border disclosure of personal information. Now, before an entity discloses personal information about an individual to a person overseas, the entity must take such steps as are reasonable in the circumstances to ensure the overseas recipient does not breach the Australian privacy principles. Now, again, you're saying overseas, well, but that's happening a fair bit now. There's instances where you're storing personal information. You might be using a cloud storage, you might be using a Dropbox or some other type of storage unit. Give some thought to where that's being stored. How is that going to apply? Most of these organisations, like to talk about the security and the encryption of the information, and it's fairly secure, but you should at the very least satisfy yourself or make the effort to satisfy yourself to ensure that this information is being looked after securely. It's not unusual now for more and more businesses to be sending data overseas to get processed. Lots of businesses now I'm aware of use cheaper process computer word processing people. They'll get the information, send it overseas, get a letter drafted up or data entry made, and then get it back to Australia, and it can be done at a much cheaper cost. So if you're sending that personal information overseas, ensure that these people are complying with the privacy principles. Privacy Principle 9 talks about adoption of government-related identifiers. An organisation must not adopt a government-related identifier of an individual as its own identifier. So if you're dealing with a government agency in the course of your business and they identify people using a particular code or method, you cannot use that method yourself. Privacy Principle 10, quality of personal information. An entity must not take such steps, or entity must take such steps, if any, as are reasonable in the circumstances to ensure that the personal information that the entity collects is accurate, up to date and complete. So you have to make sure that it's current, up to date and complete, having regard for the purpose of the use of disclosure of the information. Give some thought too about the length of time you hold information. What do you do with, you get multiple offers on a property? So you've got personal information about people who were unsuccessful buyers, or someone put in an offer and didn't go anywhere. So you've got the information there. Should you be retaining that information? I think there's probably a couple of things you think about. Firstly, you may need to retain that information down the track to protect yourself, to show that you did your job properly, that you did present the offer, in case someone wants to make out that you didn't. But how long would you keep it for? Is it reasonable for you to do so? You'd have to give some thought to the particular circumstances. If you are going to keep that information and you can justify or say you do have a need to keep it, you should make sure that's kept in a secure format. You also, as far as security goes, just be aware with if you don't need to keep this information in a hard copy. You can scan it, for example, and save it electronically. But then if you save it electronically, make sure it's somewhere that is secure. It's quite possible now, if you leave your computer system going 24 hours a day, it's connected to the internet, someone might be able to get into the back end of it and access information. So there are instances where you have to give some thought to how you're going to store this information. And that is privacy principle 11, the security of the information. So if you hold the information, you must make such steps as are reasonable in the circumstances to protect the information. If you no longer need the information for any purpose for which the information may be used or disclosed, and it's not contained in a Commonwealth record or not required by law to retain, you must take reasonable steps in the circumstances to destroy the information. Privacy principle 12, we're nearly there, 2 to go. Access to personal information. If an APP entity holds personal information about an individual, the entity must, on request of the individual, give the individual access to that information. So, unless doing so will pose threat to life or safety, would impact unreasonably on the privacy of other individuals, the request is frivolous or vexatious, relates to legal proceedings or relates to negotiations that could prejudice those negotiations. So yes, people have right to their personal information, but don't just give it out straight away. Give it some thought to why they're asking for this information, what are the circumstances of the information. It may be, especially for example, family law matters. You might be selling a property that is subject to a property dispute, a family breakup. It might be a mortgagee sale. Think about the information you have, who is asking for that information, and should you be passing that information on. So on the face of it, yes, if you have personal information about somebody, they have a right to know what you hold about them, and so on. But give some thought to the circumstances. If there's other people or other circumstances involved that may restrict or give you pause to think about, should you be releasing it. If someone asks about their personal information, you must respond in a reasonable time frame, and you can only charge a fee that is reasonable. You can't make it difficult, and you can't charge an exorbitant amount of money. Now, privacy principle 13, the last one, is if they request you to find out or give them the information that you have on them, an APP entity holds personal information about an individual and is satisfied that, having regard to a purpose for which the information is held, the information is inaccurate, out of date, incomplete, irrelevant or misleading, or the individual request you correct the information, you must take reasonable steps as an entity, if any, as are reasonable in the circumstances, to correct the information to ensure that, having regard for the purpose for which it is held, the information is accurate, up to date and complete, relevant and not misleading. So if they ask for access to the information, you must give them access to that information unless there's a circumstance as we discussed before. And if it's inaccurate, you must make sure that it is accurate, or change it to ensure that it is no longer inaccurate. It's probably a better way to do it. What do you do now? Well, the first thing I would suggest is you access and read the privacy principles. They can be accessed using the link that we will provide you. You then need to draft a privacy policy. You need to place the privacy policy on your website. I would suggest that you email all of your current database with a copy of the privacy policy. You need to also review and amend your office policy and procedures manual. There'll be some parts of your normal procedures that you will need to change. So you do need to review how you handle personal information and reduce that in writing and put that in your privacy policy and procedures manual. And if you want advice specific to your business, I'd recommend that you seek independent legal advice.